Welcome back to the Oscar Pistorius trial. It's a Carte Blanche channel. My three legal experts are Professor Stephen Tucson. I've got Billy Gundolfinger. They are our attorneys here. I've got former High Court Judge Chris Greenland as well here in the studio. We'll be going through your tweets in a short while. A number of issues, though, still to wrap up with our legal panel based on today's testimony. And Stephen, once again, I'll start with you. It was the issue of Colonel Michael Sales, who was testifying about the iPads. Now, we had anticipated that the technology or the information stored within the smartphones and the iPads might be of critical value. So much was made of the iPhones and the team that went over to Apple to try and get that information, yet we've heard nothing about it. Can I infer that possibly one of the expert witnesses still to come is going to testify on that?
Yeah, I didn't catch the whole day's proceedings. So I caught the iPad analysis, and there was very little cross-examination because so what? He was surfing the net. The crucial, we've got to keep on focusing on the issue. What was his intention at the time?
Yes.
And we're trying to draw inferences from what he did to conclude what he was thinking. The SMSs or messages, if they are timed at 3 in the morning, if they indicate some kind of conflict, they would be crucial. They would be absolutely crucial. And if they've got that, well, you know.
Because on the face of it, it would appear that that witness's testimony was of no value whatsoever. There was no cross-examination, or there was no intensive cross-examination. There's got to be a reason.
But I think that there still are 4 or 5 witnesses to be called, and I think the evidence of those witnesses, we anticipate, will support the previous witness. So,
okay, so he's laying the basis for what's still to come, is that right?
That's correct. We also know that there's the phone that was taken over to America, to Apple, and they had to unlock it, and we anticipate that the evidence that's going to, one of those 4 or 5 witnesses is going to be evidence relating to that.
Yes, Chris?
No, it is actually problematical because he hasn't led any evidence from Sales. So, was it Sales?
Sales.
Sales. To say to whom he handed that information other than to the defense. So we don't have a basis for anticipating that there's going to be a witness to say I received all this information downloaded from Sales. I'm totally bemused by it. In fact, there's a fundamental question here. In terms of what actually happened, the question arises, in what way is this evidence relevant? The judge could have actually put it to Gerinel, but since the defense didn't object, I suppose she didn't. But on its own, as we've seen it today, it actually, there's no relevance that is that we can see.
But I'm wondering if the relevance won't become more apparent when the other witnesses give their testimony.
But he hasn't linked the witness to another witness.
Oh, okay, fair enough. I'll take the point.
Let me say, knowing Gerinel, he would not have called that witness unless there was a reason for it. He wasn't. I don't think he's looking to fill in the spot, as it were. I mean, there were 108 witnesses initially. The reason that all those witnesses aren't being called is that admissions were given by the defense, which is a normal procedure at the beginning of a matter. Otherwise trials would run for an inordinate amount of time, unnecessarily.
You reckon you got it, Chris?
No, it could be. It could be. This a very unusual strategy on his part to actually put it in cross-examination to Oscar. In other words, to get Oscar to reveal the contents of whatever was downloaded.
So he just needs to establish the basis for that cross-examination.
Yeah, and if that's his plan, it's brilliant. It's brilliant.
There was another thing that was a little surprising. So much when Warrant Officer van Staden was giving his evidence, going through the photographs in that very routine manner, obviously a critical thing in terms of putting the blocks in place, and blood spatter on the wall and on the duvet, not mentioned again by the blood spatter expert, and one can surely only draw the inference that it was of no relevance, or is it something that is used in cross-examination? Stephen, what do you think?
Yeah, I was curious because I don't think there was any evidence as to whose blood it was.
It wasn't referred to?
Yeah, it wasn't referred to and it wasn't dealt with. and so we know about it. And I would think that it's inconsistent with the defence version, because we haven't heard how that played a role in the shooting and the carrying of Reeva downstairs. So I'm curious, there should be some explanation for how it got there, and none preferred by the defence, by the prosecution.
I know that I can't get you to make pronouncements about the credibility of witnesses, so I'm careful about the way I phrase this next question. Possibly this is the way to do it. Hilton Botha and the way in which he was cross-examined and the incompetencies that were revealed in the bail application established a very negative perception about crime scene management for the police. Given the testimony we've seen today, do you think credibility has been restored to some extent in the police's forensic abilities?
I do think so. And what I think is very important for me to mention is that when you bring a bail application, it was a Schedule 6 offence.
Yes.
It's necessary to get bail. You've got to show exceptional circumstances.
Right.
As we know, Oscar gave an affidavit.
The accused has to.
The accused.
Yes.
In order to get bail,
That's
you've
right.
got to show exceptional circumstances.
That's right.
So Oscar produced an affidavit, and the same could have happened for Hilton Botha. To this day, I don't understand why he placed himself in a position to be cross-examined by Barry Roux when he could have done the identical thing. He could have put up an affidavit, and at the end of the day, you can't cross-examine an affidavit. And, as we know what happened when Barry Roux got stuck
I just wonder, well, Bushy Engelbrecht might have had an answer for that when I interviewed him earlier today. He said the police just weren't prepared. They just didn't have enough time to prepare, and the only way they could actually deal with it was put him in the stand. They didn't have time to do the affidavit. It turned out to be fatal.
Inexcusable.
Yes.
It seems to me that the perception is that they are competent and they can do some things right, and I think Mangama and the blood spatter experts did restore credibility.
Stephen, I'd like a view from you on the evidence, and I know I'm going back a little bit, but Sean Wren's the firearms expert, the man who did the proficiency test on Oscar Pistorius, was taken through a number of scenarios in the test that Oscar had written, and showed that he was aware of when deadly force could be used and understood firearms competency. A number of our experts have said that that was particularly damning, though I haven't seen that reflected in media at all. What's your take on that? Was that particularly damning evidence?
It was important because it closes the door on the defence of ignorance, I didn't know, and plausible deniability. So and it also goes directly to the competent verdict of culpable homicide. He's negligent on his own understanding of the law. He failed to live up to the standard of what he knows he should have. And so it would go clearly to culpable homicide.
Chris?
Yes, what worries me about that is, as human beings, we internalize input from our environment. And we know that in South Africa, at one stage, we had almost wall-to-wall input under the banner of shoot to kill, led none other than by our chief police commissioner. And it worries me as to what extent, if any, Oscar, as an ordinary citizen, as an ordinary human being, also perhaps subconsciously internalized that culture. Because shoot to kill means when you think you're under threat, you shoot first and shoot straight. So that is an aspect that has bothered me. And I don't know to what extent this young man also internalized that input from his environment.
I wonder if that'll be something asked of him. Billy, before we go further, you raised the issue of the sentencing. It might come up in Twitter, but let's deal with it while we can now. Obviously, there are a number of scenarios. He's found guilty or not guilty. So let's not guilty.
Not guilty.
He's acquitted, off he goes.
Right.
Guilty, and I know we're looking at a bit of an end game here, and people mustn't feel we're prejudging. We're just looking at the possibility of scenarios. What happens?
So premeditated murder, you're looking at life, 25 years.
Yes.
Murder, it's 15 years, and in terms of the Minimum Sentencing Act, there's a discretionary further 5 years, so 20 years. Culpable homicide, it could be anything from a suspended sentence to 15 years imprisonment.
So those are the scenarios we've got.
And the amnesties that are normally given over the years frequently don't apply to violent crime. In other words, the time, there are certain periods during the year that amnesties are given to prisoners to shorten their sentence, but they normally do exclude violent crime.
Chris, from a judge's perspective, to what extent are you bound by statute? To what extent does the judge have discretion?
Statutes are the laws of the country.
Yes.
Everybody is bound by them. But I just want to go back once.
You misunderstand my question. When it comes to sentencing, do you have to look at statute or do you have discretion? That's what I mean.
If that particular offence or crime is regulated in terms of punishment by statute, then the judge is bound to respect and apply that statute. Typically, you'll have what's called a minimum sentence imposed by statute that says stock theft is automatic 9 years unless there are special circumstances. But just to go back one step, what's very important, in deciding whether Oscar is guilty or innocent, the court will measure his conduct in terms of what's called the reasonable man test.
Right.
So Oscar will be measured against that standard. What would a reasonable man in his position have done? As regards sentence, it changes. Then it's more or less subjective. In other words, the judge looks at Oscar as a human being and assesses his moral blameworthiness on mostly subjective factors, and then imposes a punishment which is appropriate to Oscar as a human being that has failed in that way.
How difficult is it to sentence?
It is the most difficult, it is said, that it's the most difficult duty that a judge has.
I anticipated that might be the case. Billy, hold it there. We're going to come back to our discussion with our legal panel right after the break. We'll also be answering your legal questions tweeted to us at OscarTrial199. Keep them coming and don't go away.